SJC-11756, Deutsche Bank National Trust v. Fitchburg Capital, LLC.
Good morning.
Good morning. May it please the Court. Jeffrey Angley for Fitchburg Capital, LLC. With me on brief is Nicholas Shapiro, and with me today is Robert Hopkins. The primary issue today is the application of the 2006 amendment to the obsolete mortgage statute, in particular whether or not the recitation of the underlying maturity date of the note that the mortgage secures renders that mortgage a mortgage for term, that is, a mortgage in which the term of maturity date of the mortgage is stated. If that is the case, then the mortgage is subject to a 5-year enforcement limitation period from the date of the underlying obligation matures or comes due. If it is not, then the mortgage is subject to up to a 35-year enforcement period under the obsolete mortgage statute. That's 35 years from the date that the mortgage is recorded. So in this case, the question of what limitation period applies has a significant application both to our client as well as to all mortgages in the Commonwealth, because you need to know what the limitation period is to know what the status of your record title is, your ability to refinance, what happens to the quality of title in terms of sales, financing, divorce, probate, bankruptcy, and also it affects the priority of mortgages, liens, and encumbrances of record. Now, this statute was newly enacted in 2006. Prior to the statute, mortgages were enforceable for up to a period of 50 years, and at that point, or any time before, if it had been paid, you could bring an action to discharge. What's important about the 2006 amendment is that it is self-executing, and so therefore it affects rights of parties even when there's no action that's taken, no lawsuit that's filed, no demand or notice that's been given. It simply is terminated as a matter of law in accordance with the terms of the statute.
Can I ask you this question? Looking at the Cristiano mortgage, well, I have two questions about it, but just take the language about it's, his with mortgage covenants to secure the payment of this note within a year. That same language is in the Gandolfo note, and I'm inferring, although it's not stated, that in the 45 Harvard case, it talks about the note was payable, the mortgage was payable with it. Is that a usual form of the way mortgage instruments are written?
It is, and so if you look historically, remember the 2006 statute created this new thing called a 5-year limitation period for a mortgage. Before that, it was 50 years, and so when we used to draft mortgages, we would always say that this is a mortgage that secures a note of even date in the sum of $100,000, and then what we would do is always identify the underlying obligation which the mortgage secured, because you needed to know at the time you were going to enforce your mortgage what the debt was that attached to this mortgage. So this was a referential, was informational.
You needed to know because the note isn't recorded? Why did you need to know?
Right, the note is not recorded. There may be multiple notes. The mortgage could secure multiple notes, or if not, it's just for the sake of clarity. We wouldn't want to be undertaking a foreclosure and then have the debtor say, no, I'm in default of a different note, and your mortgage doesn't secure that note. So it was always for identification purposes. And so the great offense that's being done here by the trial court was to take this idea that is finding the expression of the term of the underlying note in the mortgage and saying, now that makes this a mortgage for term. The problem is, of course, that's not what the statute says at all. It is not what the parties in this case intended, and it also does nothing to advance the interests of the statute which the legislature enacted.
Can you help me understand what is it that's supposed to be there that isn't there?
In the mortgage?
In what we have here in the record,
Yep.
There's a reference to the note. So what else do you say should be there that isn't there?
Well, I'm not sure I understand the question, Rhonda, but I think that...
Well, you say, as I'm understanding it, you say that the reference to the note is insufficient, that the mortgage itself has to have something that sets forth its terms that's different from what the term of the note is,
Okay, so there are now two kinds of mortgages. There's a mortgage when there's no term stated, and there's a mortgage where a term is stated.
Okay.
So if there's no term stated, then you have the 35-year rule. But if there is a term stated, we're saying that you have to be clear about what it is that you're doing, because there is no, think about it, when you grant money, loan money to someone, you take back this transfer of title security for the underlying obligation, you want, typically speaking, this security to last for the longest possible term. In fact, mortgages don't typically have terms. Now, for the first time, the legislature has imposed this possibility of a
mortgages often
for
are
term.
30-year mortgage, 20-year, they do have terms.
Mortgages, the underlying notes typically have terms. The mortgages are in effect for so long as the obligation remains due and payable. Now, it is possible, and I've jumped ahead a little bit, but it is certainly possible, and the legislature has now given us this opportunity to create a mortgage for a term. And I could think of two reasons when you would want to have that happen.
Well, could you, is it possible to have this goes back to something you said a minute ago. A mortgage may be securing multiple notes, and in the old days you wanted to identify a mortgage with a note. But could you have a mortgage now for 50 years and then execute a note a week later saying that this note is secured by a mortgage recorded in the Middlesex Registry of Deeds? 3 years later, you write another note.
Right.
Is that possible?
Sure. So they're really talking about a dragnet clause.
Yeah.
And this mortgage had a dragnet clause because
apart from the dragnet clause.
I think that's how a dragnet clause would work.
No. There's no dragnet clause in the mortgage.
I see.
You record a mortgage, and it's a security that's somewhere out there and floating around in the Registry of Deeds, and it's good for 35 years. And then you've got notes that are flying in all the time.
You would have to amend the mortgage. I believe you'd have to amend the mortgage.
Okay.
To be clear.
So the term of the mortgage, it really is important to it really is identified with a note.
Right. It attaches, right, because the mortgage is a security interest for the payment of that underlying obligation. And that's why it's important to know what the statutory, now this possible alternative universes are.
But it's not like a floating lien under the Uniform Commercial Code.
No, but are you agreeing that the term of the mortgage is the duration of the mortgage is identified with a note? Is that
Absolutely not. No, I'm not. In fact, this is the great problem with the construction that the trial court gave. If the parties want to create a term of a mortgage, you can do it now in Massachusetts, but you better make sure that the term that you set in your mortgage is going to give you sufficient time to enforce your note. And that the real problem with this construct is this. This court ruled in 2012, I think it was Justice Duffy's decision under Premier Capital, about notes are commercial instruments. They're subject to the Uniform Commercial Code. They have a 6-year statute of limitations. Now think about what this judge has just done. He's ruled that in reading the obsolete mortgage statute, the mortgage is a mortgage for term if under his theory, it states the term or maturity date of the underlying note, and therefore has to be enforced within 5 years. But under the UCC, you have 6 years. So you're constantly going to have this problem where your mortgage is terminating potentially at least a year prior to the enforceability of your underlying promissory note. That is a misreading of the statute, and that can't be the construction that the legislature wanted.
Can you have a mortgage that has a term longer than the term of the note that it secures?
Yeah, in fact, you would want to do that. Let's just say, for Your Honor, that you had a 5-year note, and you wanted to secure that with a mortgage. If I was going to set a term, and for example, parties may want to set a specific term because under the statute, you know exactly when it ends. So if I have a 5-year note, I would want to pick a term that would take that 5-year term. I'd add 6 years to it to pick up my enforceability under the UCC. And then I might personally want to add a couple more years in case we had an agreement to extend or there was some litigation that involved this matter. So maybe a 5-year note, if you wanted to use the statute effectively, you could say would have a 15-year term or a 12-year term.
Or a 50-year term.
Well, a 50-year term, right?
You can't do 50 anymore, can you?
Well, here's the.
Well, I suppose you
I would
can.
say this. Now, that's the other alternative. What if? Now, think back in 2006. The market is more. The real estate market is going crazy. Prices are rising rapidly. They've now reduced the standard mortgage term to 35 years. But what if I had a 50-year note? I mean, I think that there are people doing 50-year mortgages because of the price of real estate. You would have to use a mortgage for term in order to secure that, because otherwise your security is going to disappear in 35 years if you're not on a mortgage for term. I see this as the legislature giving people options about how to deal with their security. But the problem is that's not what happened in this case. In this case, Fitchburg Capital and its assignor, Borg Development Corp., clearly intended this to be a mortgage without a term. One, because it doesn't state a term.
But can I ask you, I mean, there's certainly a way to do this. I mean, first of all, if you've got a mortgage securing a 5-year note, and the mortgage references the 5-year note, you've automatically got 10 years. And then the statute says, unless an extension of the mortgage or an acknowledgement or affidavit that the mortgage is not satisfied is recorded before the end of that 10-year period, right? So you just say, well, 10 years you haven't done it, so here's an affidavit. We're recording the affidavit. It's extended further.
Well, that's right. Right, that's right. And there's nothing wrong with this statute. We're not challenging how this statute is written. This statute, we believe, works perfectly fine. You either have a note for a term or you have a note that doesn't state a term. The problem that with the trial court's decision, which we ask you to reverse, is that they took the word term or maturity date of the mortgage, the statutory language, and read that as the term or maturity date of the note. And that, as I said, creates a serious problem because your security terminates.
It's the note as referenced in the mortgage. It's the term as referenced in the mortgage. You certainly couldn't have a mortgage. I mean, if you had a mortgage that said to secure the payment of a $10,000 note, period. That's a 35-year deal, right?
That's a 35-year deal.
But to ensure the payment of 10,000 years as of December, by December 31, 2020, then that's a term, isn't it? In the mortgage, you're referencing the loan.
It is not the term of the mortgage. That is not how it would have been interpreted in the past. I mean, you had a mortgage that simply was put on record. You would identify the underlying note to know what you were securing, but that mortgage had no term. It simply existed for as long as the underlying obligation was outstanding. And once the obligation was outstanding, then the obligor had the right to request a discharge or file suit to compel a discharge.
Can I ask you, are you basically saying, I look at the statute and I think that the statute was intended to deal with mortgages already in existence as well as mortgages that will be written in the future. And it is in fact to deal with the problem of obsolete mortgages. So if I understood what you said, correctly, I think you said that mortgages were simply never written before, in which the term of the mortgage was stated. So how then can we look at the statute's purpose if, in light of that statement? I mean, if it's intended to deal with mortgages already in existence, and you're saying there is no such, it would be, we didn't know we could even write mortgages with terms.
I mean, I think that there were instances where they did happen, and I actually think of the Gandolfo case, which seemed to have said it was a mortgage for a 5-year term. I mean, it is possible. I'm not saying that they didn't exist. I'm just saying that practitioners generally didn't think of them in that way. And I think
and the statute would also have an effect in the sense that it was for everybody, limiting turning the 50 into 35. So
that's right.
For pre-existing mortgages.
But I think, so the statute, I partly don't understand, Your Honor, is what the need for this rule as adopted by the land court is, because this statute works fine on its own, and this statute is part of a very broad remedial statute that was enacted in 2006, and that was to deal with the payoff of obtaining payoffs and discharges of mortgages that had been paid. And if you take a look at this construction, it was heavy remedies. You had now a right to, once you get paid off, you had the right to your discharge in 45 days. If that didn't come, you had the right to make a demand. You could get fines of $2,500 in legal fees. You could file suit in the land court or the superior court to compel your discharge. You could even wait out a kind of a 20-year period and file suit even if you didn't have proof of payment. So I look at this obsolete mortgage statute as being kind of the final remedy if nothing else happens, if you're not active in any way as a homeowner or landowner, you could get your mortgage discharged as a matter of law.
Can I just ask you this? Even if this court were to agree with Judge Foster with respect to the Cristiano mortgage, your argument is the other mortgage, the BDP one, is explicitly a dragnet mortgage. It explicitly mentions these other, it's securing debts hereafter, and it couldn't possibly be within the 5 years, right?
That's correct.
And so you would prevail because that predated the AmeriQuest.
Correct. That's absolutely right. We have a priority interest over AmeriQuest in this case. That mortgage, the Bork Development Corporation mortgage, which was the operative mortgage that was foreclosed, was executed prior to adoption of the statute. It was then extended prior to the adoption of the statute in 2005. So that term ran until 2007. Under the UCC, we would have had until 2013 to enforce it, and we enforced it by foreclosure in 2012. It should have been a valid foreclosure. Judge Foster ruled that our mortgage interest terminated in 2008, and that is also, I said, not only misreads the statute, but also, as we argued in our brief, is as applied constitutional due process violation because it deprived us of a right that we should have been entitled to. Thank you.
All right, thank you.
Good morning, Your Honors. My name is Jeffrey Loeb. I represent Deutsche Bank. I appear before you to ask you to affirm what Judge Foster's decision. And really, I'll direct Your Honor's attention to a decision that Justice Lenk was involved in, the Harvard 45 Associates case. Justice Spotsford, you asked about the mortgage in that case. I went back, and it's not in the record. It's not in the decision, rather.
Right. It just talks about it was to be paid. The mortgage was going to be within whatever the date
It
was.
had a reference similar to Gandolfo, similar to here. And it's, for the court's reference, it's recorded at the Norfolk Registry at book 15077, page 490. Was able to find that through the record. The mortgage in Harvard 45, the mortgage in Gandolfo, went one step beyond what was the norm.
But the issue was not raised.
I differ with Your Honor. The issue as to whether or not the statute applied, whether it was a 5-year or the 35-year, was precisely the issue.
Yes, but nobody was arguing this question about whether anything on the face of the mortgage really went to the note. That was not part of the decision anyway in Harvard 45, and it wasn't part of the decision in Gandolfo.
That was the argument that was there, because the question was, if you simply, and I think it was Justice Spina's question before, how did you make reference? The traditional way of referencing a note in the mortgage was, this mortgage is to secure a promissory note dated X.
Right.
Here, and in Gandolfo, and in 45, the drafter of the mortgage, whoever that may have been, went one step beyond. They went one step beyond to say a promissory note dated X that expires in 1 year or expires in 5 years. They then created a maturity date. Keep in mind that there are two words. It's
You
term.
say so. That's not what your brother says.
I understand, but it's a question in terms of for the court to interpret. What the statute said is it's a mortgage with a term or maturity date.
Of the mortgage.
Of
the mortgage.
Of the mortgage.
Of the mortgage, not of the note, of the mortgage.
I understand. And what they've said is that it's clear from the face of the mortgage what the maturity date is of this instrument.
Well, but we don't think of mortgages as maturing, do we? It's the underlying note that matures.
I agree, Your Honor. I agree.
Doesn't it make most sense to, doesn't it make most sense to view the mortgage date, or if we call it a maturity date, and the underlying note as being coterminous? Don't they go together? Does anybody ever write a mortgage that is less time than the note?
No. One shouldn't. One shouldn't. Actually, they are coterminous. I have never seen one where it would be beyond that, because you don't need the enforcement of the mortgage separate and apart from the enforcement of the note. From a UCC standpoint, it means, can you sue on the note? Not whether or not there's debt, but can you sue personally on that note? The lien itself still exists, and so you simply need that. But from an interpretation standpoint, because to say that you have to have a term or maturity date of a mortgage, the term or maturity date of the mortgage is what the face of the mortgage says. You or I might draft it a little bit differently than was drafted in this particular case.
But what about the BDC one that has a dragnet clause that says it's securing a whole bunch of other stuff as well?
It says it may secure something else, Your Honor. It may secure it, and then the savings provision in the statute, it's there, and it says the intent is that it's going to be out there. There's no question. But then there's a savings clause in this statute. This statute is self-executing. All that Fitchburg had to do was record within the 5 years, and they had until 2008 to do it, a statement that said an underlying debt that was secured by this mortgage was still outstanding. That's all they had to do to preserve this mortgage and get another 5 years. Similar, there was a comment made about the UCC, similar to what one would do with a UCC-3 continuation statement.
But if we view the mortgage as containing dates that are referring to a note, then don't we have a non-specified maturity date in the mortgage? And the mortgage is good for 35 years.
No, Your Honor. If the mortgage, as is the case in the BDC mortgage and the Cristiano mortgage, where there is a specific due date on the Cristiano, where it says due within 1 year and it has a specific date, the BDC due within 5 has a specific date, then those are specific term or maturity date. If, however, it simply said,
but specific maturity dates for the note.
for that obligation, for that mortgage and note that are secured, that are a parcel, that they are together, and they work in tandem, as this court made clear in Eaton, that you can't do anything with the mortgage without the note. They work in tandem. And so you have those two, and that would be the no term or maturity date would simply be the mortgage that said this is to secure a promissory note of dated X. That would be the separate obligation. That would be the undefined.
Before the 2006 statute, was it in the real estate bar, was it thought that mortgages had terms?
Your Honor, I can't answer. I don't know the answer to that question in terms of what the real estate bar's view was as to whether mortgages had terms.
They were alive, essentially, as long as the underlying debt was alive.
Well, I would say that they were alive, and the problem that this statute in general was trying to address is that they were viewed as alive as long as there wasn't a discharge of record at the registry. And that was the concern that was being addressed here, not only in this section of the statute, but in the other sections of the statute, to try and figure out ways to get missing discharges.
So help me to understand the purpose of the statute. I mean, clearly they wanted to change the obsolete mortgage statute. And what was the evil that they were, or the harm that they were trying to prevent?
What the harm that they were trying to prevent, Your Honor, was mortgages that were simply of record at the registry that were creating what appeared to be clouds of record. Whether those clouds were real or not, whether there was still an obligation outstanding or not, and to deal with situations where you had mortgage holders who were sitting on rights, who were not taking any steps to enforce, thereby creating what appeared to be clouds and doing nothing to enforce. And this was a way to really create a statute of limitations where one did not exist previously.
But when you say where they were choosing not to enforce, was that in circumstances in which the debt had been paid?
Oh, they could. Well, if the debt had been paid, then it was for reasons best known to the parties where a discharge hadn't been recorded.
That's what you said earlier, and then that seemed to me to have been a problem earlier, which was so many mortgages, so many, but you weren't getting the discharge after it was paid. That's the issue that it seems as though this statute's trying to address.
Within Chapter 63 of the Acts and Resolves of 2006, Your Honor, absolutely, there are sections within that Act and Resolve that dealt specifically with the delays in getting discharges, and I'll be generous in that regard, I think in some circumstances, the difficulties in getting discharges where things have been addressed. There is no question about it. That was one of the variety of issues that were addressed within Act and Resolve 63. This was this happened to be within that same Act and Resolve, but addressing the overall issue of mortgages and the fact that mortgages were of record longer than the legislature felt they should be. And that for whatever reason, and that was, that's my reading into what the legislature was doing in this, and they were putting in place a shorter statute of limitations.
So if that's their purpose, I assume that clarity is key, because that would enable somebody reviewing the title to say, well, there is this old mortgage, but I'm confident from the language of the mortgage that it's now obsolete.
Yes, Your Honor, which is hence for example, the date, the fact that in the mortgage, in the Cristiano mortgage, where we have that 1-year date, somebody could then look at it and say, we're now 5 years post that date, therefore this mortgage is deemed discharged.
Well, that happened here, and we have a lawsuit.
Yes.
So the statute didn't solve anything.
I would beg to differ, because we're now 8+ years from the effective date of this statute. This is the first time that an issue relative to this statute has made it before this court. There is, I believe, only one, and I may be mistaken on this, one reported state appeals court decision on it. I think, quite candidly, most of these issues are dealt with by title examiners. They look at it, they make a decision, and folks move forward.
And what do? Record an affidavit? It's my opinion that this is...
It's looking at it on the face, Your Honor, because the statute makes it clear for recorded land, and I'll deal with registered land separately. For recorded land, if you've got that date and you're 5 years post the date, folks simply move forward. On the registered land side, you do have to pay a $100 fee, and there's a separate piece of paper that has to get recorded or registered.
So if there's a specific date and the obligation lasts for a certain period of time, or if there's a date in which the obligation ends, for all practical purposes, that is the governing date for the application of the statute.
Yes, and that is how title examiners, that is how this is being viewed in terms of what is the maturity date.
As long as it's reflected in the mortgage.
As long as it's reflected in the mortgage.
Well, that's not, you say that's how title examiner, I mean, is that part of the record, or are you just saying that's your experience?
No, I was asked the question, I was saying that's...
Okay, I'm not blaming you, I'm just...
No, Your Honor is absolutely correct, Justice Spotsford. It's not part of the record, it was not part of the discussion at the land court. I'm simply saying that's what's happening in terms of the reality.
So if you focus on clarity, which is more clear, your argument or your brother's argument?
I think my argument, Your Honor, because if you look at the concept of is there a maturity date? Is there a date that's clear from the face of the mortgage? The answer, with respect to these two mortgages, the answer is yes.
And if there's a dragnet clause in the mortgage and you don't know what additional mortgages or notes are being picked up by the...
Quite frankly, Your Honor, it's a drafting issue on the part of the person who it's the mortgagee's issue. They drafted the mortgage including that maturity date. They then have a savings under the statute to extend for another 5 years if there's further debt that's outstanding. They had that opportunity.
But where's it, I don't understand this savings thing. What are you talking about?
Within Section 34 of the statute, Your Honor.
Yeah.
When you get to the 5-year point, you as the holder of the mortgage have the right to go to the registry and record a statement signed simply by you as the holder of the mortgage.
That, yeah, okay.
Yeah. And that extends it another 5 years.
That extends it another 5 years. That's all you have, and that's why I say it's identical to a UCC-3 continuation statement that you as the secured party, the holder of the mortgage, have the right to go and extend.
And you can do that an unlimited number of times?
Absolutely. If there are no, I don't know if the court has any questions on the constitutional issue that's been briefed. I know that was the other issue.
Well,
that was before
I have a question about the subrogation, equitable subrogation. I don't understand how you get to equitable subrogation, I must say. This was a refinancing, wasn't it?
Yes.
Well, doesn't Ogden say in a footnote that refinancing is different than equitable subrogation?
Refis, the equitable subrogation applies in a refinancing context, Your Honor. Ogden has it a little bit differently, but I would also suggest that that's not before the court at this point, as I say in my brief. The only
But it is if you don't prevail on the statute.
If I don't prevail on the statute, then it would go back to the
Well, maybe or maybe not. I mean, doesn't necessarily have to go back.
No, but I would suggest, well, the judgment that entered only entered as to the mortgage. It was a separate entry of judgment simply on the obsolete mortgage statute issue. That's the only thing that's before the court right now.
Mm-hmm. On the constitutionality question, it's not in the facts of this case, but if you had a 25-year mortgage and note, and it was clear from the face of the mortgage that it was a 25-year mortgage, and here we are now, after the statute is passed, and we're up to around 32 years. The statute could have gone into effect and cut off somebody's rights, even to update, to continue the mortgage for 5 years.
No, I don't believe. I don't believe so, Your Honor. And if I misunderstand Your Honor's fact pattern, let me try.
The statute went into effect in 2006.
Yes, Your Honor.
If you had a mortgage that was written in 1970, a 25-year mortgage, 1975, you have a 25-year mortgage. So here we are at 2005, the 5-year period is gone. The statute's passed in 2006 with a retroactive effect, and there hasn't been any continuation affidavit filed.
Correct, and that's what and that's what I submit. The legislature took that fact pattern into account in delaying the effective date. As Your Honors are well aware, normally the timeline between enactment and effective date is 90 days.
Can I ask you?
In this, it was extended to roughly 180 days. I'm sorry, Justice Cordy.
No, that's fine. I'm just reading this, we'll call it the savings clause, this extension clause. Does that apply both to the 30-year limit as well as the 5, would you say?
Which?
This is the unless an extension of the mortgage or an acknowledgement of the affidavit, acknowledgement or affidavit has been filed that the mortgage is not satisfied.
I submit, Your Honor, that applies to all mortgages.
Okay, applies to the 35-year limit as well as the 5-year
yes.
limit. Okay, that's what I thought. Thank
yes.
you.
And just to speak, did I address your question?
So there's a very short window of opportunity for those mortgage holders to extend their mortgage.
Yes, and all they have to do, unlike, for example, this court's decision in Chaffee, where the court said, well, it's a simple matter of filing a complaint. Here, you didn't even need to file the complaint. Simply needed to file really a 1-paragraph document at the registry that would buy you another 5 years.
Okay.
All right, thank you, Your Honor.